Today's lecture focuses on litigating human rights cases in national courts. I want to introduce you to some of the basic topics in this area of the law and provide you with some ways of thinking about some of the key issues that are faced when an attorney or a litigant attempts to bring a human rights case in a national legal system. Let's start with a couple of the key questions that we'll be talking about today. We'll think first about some of the benefits and the risks of litigating human rights cases in national courts. We'll then turn to some of the different mechanisms or modalities by which this litigation occurs. And then we'll step back for a bit and assess some of what we've discussed. Let's start with looking at some of the benefits and the risks. I've identified for you on this slide some of the key benefits, and I think they're considerable. Judges are generally independent. The decisions they issue are legally binding, unlike some of the mechanisms we looked at the international level, where recommendations or decisions are non-binding. Remedies that judges provide can be given quite quickly, particularly in cases of exigency or urgency, such as preliminary injunctions. Monitoring mechanisms are often more robust and more established at the national level, in part because national judges are closer to the institutions, actors, and situations that human rights complainants are addressing in the cases that they bring. In addition, compliance rates with national court rulings are generally quite high, and it's also worth noting that if a potential applicant or litigant is interested in bringing a case to the international level, that exhaustion of domestic remedies is required if those domestic remedies are available and effective and not unreasonably prolonged. And so litigation before national courts may be one way to provide a foundation for moving to the international level if rights are not vindicated. But they often are vindicated at the national level, and that's really, I think, one of the key benefits to bringing human rights cases in national courts. You don't need to go to the international level. What are some of the risks, then, in litigating human rights cases in national courts? In some countries, judges are not independent. This might be because they are still in office from a prior regime that was authoritarian. It may be because the political process by which they are appointed or renewed gives them some considerable ties to the government in power. This is also, I should note, not a binary issue. It's not as if judges are independent or not. They might be partially independent and partially dependent on the government. So this is an issue that will vary from country to country. Another thing to keep in mind is that judicial proceedings in some national legal systems can be expensive and time-consuming, with cases languishing on the docket of the court for many years. National courts will attempt to process cases in a timely and expeditious manner, but much depends on the resources that governments provide to judges and to judicial staff to allow them to process cases in that way. Another risk of national litigation relates to the possibility that rights in domestic legal systems might be construed more narrowly than rights at the international level, and a litigant whose rights falls within that broader definition would not be able to obtain relief at the national level. Finally, it's worth noting that litigation may not be appropriate for certain types of human rights issues. These include mass or systemic violations in which a country is experiencing widespread civil unrest or violence. In these sorts of situations, judges, whether international or domestic, are unlikely to be very effective. But let's focus on those situations in which judges might be effective. And here we should turn to some of the modalities by which litigation at the national level of fundamental rights and freedoms occurs. So one way that such litigation occurs involves domestic constitutions. It's the case that many national legal systems around the world have constitutions that incorporate many of the same rights and freedoms found in the UDHR and in international instruments, including the treaties that we've studied. And so a decision upholding rights under a domestic constitution might be just as beneficial for the complaining party whose rights have been found to be violated as a decision applying international law. It's also worth noting that many constitutions are explicitly modeled on the Universal Declaration of Human Rights and the provisions that it contains, or in other international agreements. So there's actually quite a bit of commonality here. You may recall in the first week of the course we discussed Professor Henkin's concepts of internationalization of rights and universalization of rights. The latter concept, universalization, involved the spread of rights to national constitutions around the world. So internationalization is an issue that we've looked at in the first few weeks of the course, and now, in a sense, we're turning to universalization and looking at how specifically rights get incorporated into national constitutions and other legal instruments. Now, it's also worth noting that some national courts consider human rights treaties, the decisions of international courts and tribunals, and recommendations of treaty bodies when they interpret domestic rights and freedoms. As a result, even if it's the case that a domestic constitution contains a right that on paper is defined differently, perhaps more narrowly, than its international equivalent, judges could very well refer to these international sources and decide to interpret domestic rights in harmony with international commitments that the state has undertaken in the human rights area. So that, in a nutshell, is how constitutions can be a source of rights that can be litigated in national courts. Another possibility is statutes, domestic legislation. And it's true that around the world, many domestic statutes have important rights protections. Let me give you a few examples. Here you see, first, civil rights statutes, such as Title VII of the U.S. Civil Rights Act, which prohibits employment discrimination on various grounds. Another example might be incorporation statutes, that is, those laws that domesticate or give effect to international agreements that protect human rights. And here I've given you an example from the United Kingdom. A third example focuses on protecting individuals whose rights have been violated elsewhere. And here I've given you an example of a statute that authorizes suits for certain kinds of violations relating to terrorist acts that was adopted by Canada in 2012. These different domestic statutes all provide ways to incorporate international norms into national legal systems, and those statutes can be interpreted and applied by courts and by administrative agencies. Now let's turn to the issue of litigating human rights cases under international human rights treaties. Here we're not talking about litigation that occurs at the international level, rather we're talking about the extent to which domestic courts can interpret and apply treaties directly. This issue depends very much on what sort of approach a country has adopted to the relationship between international and domestic law. Let me give you an example. So, in so-called monist legal systems, these are legal systems that treat international and domestic norms as part of the same legal order. It is often the case that once a treaty, including a human rights agreement, is properly ratified by the state, it becomes directly effective or directly enforceable in the national legal order and can be interpreted and applied by judges right away. An alternative approach, dualism, views the two legal systems, domestic and international, as separate. In these countries, the ratification of a treaty creates rights or obligations for the state vis-a-vis other states and perhaps even vis-a-vis individuals, but only in the international system. Within the domestic legal order, that ratification has no effect unless the government has domesticated the treaty through implementing legislation. And in the absence of that legislation, a treaty that is legally valid at the international level might not have any domestic effect. Now, it's worth noting that many legal systems are in between these two extremes. They're neither pure monist nor pure dualist, but they have some sort of hybrid approach, where some treaties have automatic effect and others do not. It's a complex topic, and one that I invite you to explore through other sources and readings. Let's step back now for a moment and evaluate the litigation of human rights issues in national courts. I think it's fair to say that this is one of the most effective ways to promote and protect human rights, to the extent that international norms are brought into and incorporated within a domestic legal system, whether that's through a constitution, a statutory scheme, through a treaty that has some kind of direct effect. That provides a way for national legal actors, in particular domestic judges, to interpret and apply that law in ways that can provide relief and remedies to those whose rights have allegedly been violated. So for those of you thinking about different ways by which international human rights can be effectuated and concerns about compliance, this is something that's worth thinking about as a strategy. How would you get international norms to be domesticated? That said, it is indeed the case that the success or effectiveness of this strategy depends, in part, on the willingness of judges to apply it. And so how independent judges are, how faithful they are to the rule of law, is going to be a very important determining factor in whether this strategy will bear fruit. I'll leave you with a number of sources for further exploration of this topic, which you can find linked on the External Resources page.